House to be again in committee on the Healthcare International Arrangements Bill, Baroness Blackwood of North Oxford.
My Lords, I beg to move the House to once more resolve itself into a committee on the bill.
The question is that the House do now again resolve itself into a committee upon the bill. As many of that opinion will say content, the contrary not content, the contents have it. In Clause 5, Amendment 26, Lord Marks of Henley-on-Thames.
My Lords, the amendments in this group all concern the Henry VIII powers in the bill. And without going into the details of the drafting of my amendments, because they hang together, I make one central point. It is my contention that given the breadth of the powers as they currently appear in the bill, the only Henry VIII powers enabling the Secretary of State to make regulations amending, repealing or revoking either primary legislation or EU retained law should be those that are limited to consequential, supplementary, incidental, transitional, transitory or saving provision. And my Lords, that's quite a wide category for these powers in any case. My Lords, if when the bill comes back at report the government has changed its position and the Henry VIII powers in the bill are limited to those which it can justify in accordance with what I might call a conventional approach to permitting secondary legislation to amend, revoke or modify limited categories of primary legislation, then we may change our position. But for the moment, we stand by the position taken by the Delegated Powers Committee, who described the Henry VIII powers in this bill in trenchant terms. The bill contains a Henry VIII power to amend or repeal any Act of Parliament ever passed. The power may be used for the purposes mentioned in Clause 5.3. But those powers are no narrower than the purposes of the bill as a whole. And I'll read them. Regulations under Section 2 may amend, repeal or revoke primary legislation, A, for the purpose of conferring functions on the Secretary of State or on any other person, including conferring a discretion, B, to give effect to a healthcare agreement. They could scarcely be narrower, and to describe those purposes as limiting is to misuse the English language. My Lords, the committee pointed out that the Minister does not give any indication of what primary legislation might in future need to be amended. She says that there may be a need to confer functions on healthcare bodies at some stage in the future, to which the committee's robust and, I suggest, accurate response that the time to confer functions on such bodies is when those bodies are created. My Lords, we should all remember why such powers are called Henry VIII powers. Their name is a reference to the Statute of Proclamations of 1539, which effectively enabled the Crown to govern by decree, ordering that proclamations should be obeyed as though they were made by Act of Parliament. Sir William Blackstone, after whom the great human rights set of chambers of which the noble Lord Panic is a member, is named, writing in the 18th century in his commentary on the laws of England, described the Act as a statute calculated to introduce the most despotic tyranny, and which must have proved fatal to the liberties of this kingdom had it not been luckily repealed. My lords, those words are as true now as they ever were. When it comes to EU retained law, I suggest that that law, certainly as far as primary EU retained law is concerned, the principles are the same. The Constitution Committee report draws attention to the distinction specifically drawn in Section 7 of the EU Withdrawal Act between retained direct principal EU legislation and retained direct minor legislation, as to which less stringent conditions are imposed for its modification. In this bill, the government has simply ignored the distinction. The Constitution Committee said this: one of the purposes of drawing the distinction was to make it possible for subsequent Acts of Parliament to afford greater protection to retained direct principal legislation, such as by requiring delegated powers that amend it to be subject to the affirmative procedure. Then in bold they continued, we recommend that Clause 5 be amended to reflect the distinction drawn in the EU Withdrawal Act 2018 between principal and minor retained direct EU legislation. The report drew attention to the fact that the committee had made the same recommendation in its report on the trade bill, and that the government in its response to that report had accepted it. The report went on, we recommend that the government ensures that all future bills that provide for the amendment or repeal of retained EU law include the distinction between principal and minor retained direct EU legislation. I ask the Minister, why has the government not accepted the committee's recommendation on this occasion? And secondly, will the government commit to complying with the committee's general recommendation for the future? My Lords, I agree with the point made by the Delegated Powers Committee, and often made in this House, that if a power is too wide and its delegation is inappropriate, those fundamental defects cannot be cured by making them subject to the affirmative rather than the negative procedure. If they shouldn't be there, then they shouldn't be there. And packing them up in an affirmative procedure box doesn't make them more acceptable. My Lords, in other contexts, the noble lady has shown herself to be sensitive to the distinction between primary and secondary legislation. Only yesterday, in answer to Baroness Deitch's suggestion that a regulatory change might be appropriate to change the 10-year limit for the storage of frozen eggs under the Human Fertilisation and Embryology Act 1990, she said that she did not agree that the regulatory route would be appropriate, as it was not envisaged at the time of the legislation. She said that given that this was such sensitive legislation, the government and she believed that continuing with primary legislation would be appropriate. My Lords, I urge her and the government, and urge her to bring pressure to bear on other members of the government, to extend that kind of sensitivity to this bill, to accept that the principle is applicable here, and that allowing for future regulatory change to primary legislation on an unrestricted basis, as this bill does, is unacceptable and unconstitutional. I beg to move.
Amendment proposed in Clause 5, page 3, line 36. Leave out paragraph E. Amendment 26.
My Lords, may I speak to Amendments 37 and 39, which are in this group and are in my name. the noble Lord Marks has helpfully, effectively introduced them, since the point that he made toward the latter part of his remarks was about the distinction made in the EU Withdrawal Act between retained direct principal EU law and retained direct minor EU law. Now, as the noble Lord said, the recommendation that the principal EU legislation should be subject to the affirmative procedure was recommended for the trade bill, was accepted by the government, but hasn't been incorporated into this piece of legislation. And my amendments 37 and 39 are to do precisely what the Select Committee on the Constitution recommended on Monday. Happily, I put the amendments down last week rather than waiting till after Monday. They would have been rather late. So they're there, and they allow the government to indicate their support for this process. I hope they're drafted correctly. I hope they would do the job, but even if they don't, we have the opportunity at report for that to be remedied. And I do hope that my noble friend on the front bench will say that it is the government's intention to make this change. There is, I might say, participating in the committee stage of the trade bill, as well as the this healthcare international arrangements bill, does on occasion give one the opportunity to make a positive comparison between the two. It is, however, getting very confusing, because the trade bill consists of a bill that is intended to roll over existing agreements and specifically does nothing else. And members, not least on the other side, are spending much of their time trying to persuade the government that the bill should include reference to how things should be agreed in the future. This bill takes a power not only to roll over existing agreements, but to make new ones. And we spent most of our time on Tuesday with members of the House arguing that that was inappropriate and it should be left to future legislation. So you can't, as they say, you can't have it both ways. But it seems to me that in this particular instance, we can at least, on this very specific point, ask ministers to change the bill for this purpose. So I do commend Amendments 37 and 39, which would incorporate an affirmative requirement for amendments to retain direct principal EU law to the front bench.
Well, I'd like to strongly support the noble Lord Marks in his amendment and everything he said. I fear that with the welter of things that are happening in politics at the moment, this kind of bill is getting through itself without proper scrutiny. And I fear that many, many people in both houses don't realise the importance of what we're considering and the implications of what we're considering and the far-reaching implications of what we're considering. And therefore we are really grateful to people like Lord Marks for drawing attention to this. I'm just astonished that this apparently has got through unchallenged in the other place. And some of my colleagues, with the notable exception of Baroness Thornton and her colleagues on the front bench, haven't realised, many of my backbench colleagues haven't realised what an urgent matter this is and how important a matter this is. I arrived late on Tuesday and was unable to participate in the debate on the First Amendment. And I missed the wonderful speech by the noble Lord Judge. And he raised it again in the issue at question time today and was answered by the noble Lord Young of Coodham, who is with us here today. And the astonishing thing was, and he said it again today, and he said it on Tuesday, that the harsh reality is summarised in the fact that it is exactly 40 years since the other place rejected a statutory instrument. 40 years. So for the last 40 years, we have been dealing with legislation without the ability to amend it. Whether it's affirmative or, and we're coming to this later on, or negative, doesn't matter which procedure it's been, we haven't had the opportunity to amend it. So what happens when we get this? We get a statutory instrument drawn up by the civil servants, put forward by the government to Parliament, and what is Parliament asked to do? You have to agree it or not. And if you don't agree it, you get threats. You get people saying, this is a killer amendment, this is a killer resolution. And that happened yesterday, I think, to a couple of statutory instruments, and in fact it wasn't moved in the end. So it's a take it or leave it situation that we have with statutory instruments, unlike primary legislation. And this has been the subject, and that was raised, and I think the noble Lord Young of Cudham said that's a much wider issue. It had been raised in the wider context. But what's happening is that a trickle of SIs has become a flood, and more and more and more issues are that ought to be dealt with by primary legislation are being dealt with by secondary legislation. And the more that happens, the bigger the transfer from the legislature of powers from the legislature to the executive. And that's exactly what's happening. Now, this government is doing it, and I ask the government to think carefully, because this Conservative government will not be in power forever. And I hope some people are going to agree with me on that. Here, somebody. Thank you, my noble friends. And I wonder what Baroness Blackwood, Lord Young, and Baroness Mansour, sitting there, think that the possibility of my good friend Jeremy Corbyn bringing in legislation through statutory instrument after statutory instrument after statutory instrument without any ability for scrutiny by the Conservative opposition. Yeah, that has to be thought of. This is a parliamentary democracy, and people have to think about that and think what they're storing them up for themselves. And that is exactly what's happening. And I must go back to what this excellent speech by the noble Lord Judge, when he said, a late Victorian, or maybe Edwardian professor of history, described Henry VIII as, quote, the mighty lord who broke the bonds of Rome. And then he went on to say, but even Henry VIII was compelled to do it through express primary legislation enacted in the Reformation Parliament. Express primary legislation. On one view, it may be a misdescription to call this a Henry VIII clause, bearing in mind that it applies to both UK and EU primary legislation. Perhaps in this context, it is a Henry XVI clause, which I thought was a rather wonderful description of it. Now, earlier on, the noble Lord Judge at question time said, and I thought it was very amusing, we all thought it was very amusing, that we might issue a commemorative stamp of 40 years since the last statutory instrument was overturned by the other place. And that was a lovely description, but it is a very serious matter. When it is appropriate statutory instruments, appropriate secondary legislation, then I can understand that it's a take it or leave it. But when it gets into the area of consideration that ought to be done through primary legislation, then we really are getting into very dangerous territory indeed. And I hope that the Minister, in this context of this bill, and the government in the wider context of other bills, will realise the constitutional implications of what they're proposing, and realising that their short-term political expediency will have some long-term consequences which they might live to regret.
My Lords, I agree with the noble Lord that our parliamentary processes for dealing with statutory instruments are unsatisfactory, in particular that we can't amend them. But isn't the remedy to this in Parliament's hands? Because if we were a little bolder and did reject some statutory instruments, it's not difficult for the government to reintroduce them in an amended form. The amendment can be very slight. And it seems to me that, particularly when we are dealing with all these statutory instruments as a result of our leaving the European Union, statutory instruments are necessary. And therefore we need to look very carefully at the parliamentary process for dealing with them. And it seems to me that actually, as I think the noble Lord the Minister said at question time, this is in Parliament's hands, and we could be bolder and we could achieve the objective of amending statutory instruments by rejecting some of them.
I think it is quite important to realise that statutory instruments are a very useful way of dealing with particular situations. But of course, it is extremely important that the powers to make these instruments are properly scrutinised and are narrow. As Lord Wilson of Denton said on the last day when this bill was being considered, in his day, Parliamentary Council would say, "What do you want to use this for?" "Oh, not sure, maybe." "Well, in that case, I'm not drafting it until you know what it is for." And I think that it's extremely important that these provisions should not be too wide. There are two questions that have been raised in connection with this bill. One is of that kind in the speech of my noble and learned friend, Lord Judge, and spoken to by others, including, for example, Lord Wilson. But the second point is as to the scope of the bill. And it said this is a Brexit bill. Well, it's a Brexit bill in the sense that it's occasioned by the need for a provision dealing with this matter arising from Brexit. But I see no reason why the scope of the bill should be restricted to other European countries. I see no reason why this particular problem can't be addressed also in relation to the other possibilities, so long as the powers that are given in respect of these are properly restricted. And I think the amendments that the noble Lord Marks referred to are examples of provisions that are really much too wide. And the problem is that if you try to do it too widely, you damage the argument for the scope. And in my view, if the bill properly restricted the powers that arise in connection with really intimate matters that are required rather particularly, then you help to support the argument for the wider scope. The other thing I want to say is that in relation to the amendment of statutory instruments, I'm not at all certain in my own mind, and my experience of this is rather long, in the sense that you're much better if the thing has to be amended, put it back and let it be reconsidered. That's the real purpose of the way in which the system was developed, that you shouldn't allow an instrument to pass which is defective. What you should do is throw it out and let the government amend it.
Lord will give way. I was going to say it in intervention in the previous, in Lord Butler's speech, when it applies equally here. And that is, certainly that can be done, but I've got to be careful not to give away too many secrets and internal arrangements. But if a chief whip comes to you and says, this is a purely theoretical example, and says to you, by voting against this, it's a fatal motion, and urges you not to do it, and it's very difficult when that kind of situation builds up, and it may well happen, or it may well already have happened, without giving any too much away.
Well, so far as I'm concerned, if that a defect was pointed out in the statutory instrument, that's a matter that I would wish to consider for stopping it going forward. Most of the arguments I've heard in recent times don't point to any mistake in the instrument. They're more theoretical. I don't wish to examine them again in detail. I've done that once. But I think it is important, I think that's what was proposed originally when these instruments were put forward. I think it's much easier to amend an instrument by taking it back and starting again than it is with an Act of Parliament. And I think that that is the appropriate procedure for correcting a defective instrument. And it happens not necessarily formally, but quite often instruments are withdrawn on it being pointed out that there's a mistake, and they get round to writing it again, and hopefully the second time it's improved.
It's worth mentioning Amendment 28 in the name of Lord Patel, which I think he says was covered by the noble Lord Marks of Henley. It is a quite extraordinary provision that he directs our attention to. It's at page 3, line 40, and in subsection 3, we're asked to approve of a subsection which allows regulations to be made amending, repealing or revoking primary legislation for the purpose of conferring functions on the Secretary of State or on any other person. An extraordinarily wide provision. And I mean, I can understand conferring powers on the Secretary of State, but why on any other person? And then it adds, including conferring a discretion. I mean, that really is the most extraordinary broad provision, which should be looked at very carefully.
My Lords, I thank my convener, the noble and learned Lord Hope, for bringing attention to my amendment. I was going to be briefer than brief, because Lord Marks of Henley-on-Thames not only introduced my amendment, but spoke to it. But my purpose in the amendment was to bring attention to exactly what noble Lord and learned Lord Hope has just said. It is an extraordinary powers to take. And I fear that it is this kind of powers that has probably led to the Constitution Committee to suggest that the only way for the Parliament to get scrutiny subsequently of this bill might be to introduce such draconian, I say draconian because I'm worried that it may have other implications of amendment such as a sunset clause. Because as I said in my speech on Monday, I worry if that's going to affect what the agreements, particularly with EU in the future, might do. But with no doubt we'll have another opportunity to discuss that. But I'd like to...
Just for completeness, I think the noble Lords, in relation to this amendment, which would remove subsection 3, it should be recognised that the power to which the noble and learned Lord Hope referred is for the purpose of to give effect to a healthcare agreement. It isn't for any other purpose. So if it was not in pursuance of a healthcare agreement, the power would not be available. So there is, albeit that healthcare agreements may themselves be relatively wide-ranging, it can only be used for that purpose.
I'm not too sure about that, because the Delegatory Powers and Regulatory Committee in their report said that the Minister does not give any indication of what primary legislation might in future need to be amended.
Well, but I think subsection 3 is very clear. This is a power to amend, etc., primary legislation for the purpose of conferring functions on the Secretary of State, etc., to give effect to a healthcare agreement. I mean, the noble Lord and learned Lord will know that at least limits the scope.
The noble Lord Lansley raises a very interesting point. It's something that should be clarified by better drafting, and in some ways by splitting this into subheads, as is done frequently throughout this bill. It tends to open up the arguments to which the noble Lord Patel has drawn attention. And I think I've mentioned this outside this chamber to the noble Baroness Minister, that the way these are drafted in the sort of cumulative form, is rather unfortunate, because if these things are read together in a single sentence, you can narrow them down. Whereas if you separate them out, it suggests that subhead A has a life of its own, and you wonder what any other person can possibly refer to. So I hope the noble Baroness and Minister will take these points away and ask the draftsman to look more carefully at the way this bill is drafted, particularly by the use of that style of drafting.
My Lords, I think this has been a very powerful and useful debate to have, and is a precursor to the debate we're about to have, where we will be again addressing the nature of the powers on the bill. I do enjoy very much when noble lords like noble Lord and learned Lord Hopes uses words like rather unfortunate, because, of course, in House of Lords speak, and the noble lady and the minister will become accustomed to this, that's actually really a very serious thing to say about a piece of legislation, that its drafting is rather unfortunate. And I'd like to say how much I appreciated the interventions from the noble Lord Butler and the noble and learned Lord Mackay of Clashfern, to whom I always listen most carefully. And I think that my noble friend Lord Foulkes referred to the issue of discussions that might take place outside the chamber about referral back of statutory instruments and so on. But of course, actually, we know from the past that when your Lordship's chamber gets very exercised about a statutory instrument, you know, we see threats in the press about our existence and how dare we. And I think that is a serious problem. So I think there is a broader issue than just this bill that we need to address. I think that
to the noble lady for giving way. But it seems to me that the situation is exactly the same with amendments to primary legislation. Governments will often put pressure on their backbenchers to support it, but very often the government is defeated on amendments and legislation is thereby improved. I can't see why the same thing shouldn't happen with statutory instruments.
The noble Lord and I absolutely agree about that. I think the noble Lord is quite right. And I'm not saying that one will bow to that pressure at all, and that your Lordship's House has a very, very proud record of persuading the government to change both statutory instruments and primary legislation with regard to the powers that it has. I just want to say one final thing, which is that it's not the case that these issues were not raised by my honourable friends in the House of Commons. In fact, they were. And in fact, the first report of the Delegated Legislation Committee was quoted extensively in at the committee stage in the Commons. Unfortunately, the votes were not there to carry its effects through. So we might think about changing that at a later stage in the bill.
My Lords, firstly I would like to thank the noble Lord Marks for Amendments 26, 29, 30 and 31, the noble Lord Patel for Amendment 30, and my noble friend Lord Lansley for Amendment 37 and 39, and for all your Lordships who have participated in this debate, which has been very robust. These amendments seek to address concerns raised about the ability to make consequential changes to primary legislation using regulations under the bill. I would like to reassure noble lords that the government have been listening very closely to these concerns. Some, as the noble Lord Marks put it, trenchantly expressed at previous points in this committee stage, and I want to continue these conversations as we move towards report stage. With that said, I would like to take this opportunity to provide some context for the approach that we've taken in the bill. The Henry VIII powers in this bill aren't freestanding. They flow directly from the delegated powers in Clause 2.1, which I know has also met with a little bit of disapprobation. The noble Lord Butler recognises the importance of parliamentary scrutiny, and we do as well, and the concerns over the Henry VIII powers. And the bill has been drafted to ensure that regulations making such changes would all be subject to the affirmative procedure. The intention of including this power is to make consequential changes to primary legislation is simply to ensure that healthcare agreements are implemented in an efficient and effective way. There's a broad legislative landscape which currently implements reciprocal healthcare arrangements with the EU. It currently includes EU law as well as domestic and primary and secondary legislation. In implementing future comprehensive healthcare agreements, we do think that it may be necessary to amend different types of legislation so that we can operationalise those domestically. In the past, when we have had to implement international healthcare agreements in this way, amendments were needed to primary legislation. So, for example, when we implemented the EU Cross-Border Healthcare Directive in 2013, we needed to insert discrete new sections into the National Health Service Act 2006. And it was with that specific experience in mind that we felt that it was important that the bill was able to amend primary legislation, because it seemed likely that it would be necessary to implement, in order to implement future agreements, albeit in very restricted circumstances and subject to the affirmative procedure. Now, we can give some reassurance that this is not a standalone power, and it will not need to be used in the vast majority of regulations made under the bill. Our intention in including this was only to ensure that the statute book is coherent when implementing future arrangements under the bill. Now, I recognise that there is serious concern for your noble lordships on this matter. I'm grateful for your thorough scrutiny on this matter so far, and I do want to give my reassurance that the government has listened very carefully to this, and we welcome further discussion on this critical issue before report stage. I'd also like to thank my noble friend Lord Lansley for his amendments 37 and 39. It is only right that parliamentary time is allowed for regulations that need enhanced scrutiny, but it is not appropriate for all regulations. The concept of retained EU law, of course, was introduced in the European Union Withdrawal Act 2008, and the issue of the status of retained EU law was considered during the passage of that Act, which I'm sure he was involved in. As a result of those considerations, the EUWA set out bespoke rules determining how types of EU retained law might be modified, and this was set out in Section 7 and Schedule 8 of that Act, as I know he is well aware. And crucially, the EUWA does not require that all amendments to retained direct principal EU law must be subject to the affirmative procedure, and that's true both in relation to regulations made under the EUWA or regulations made under other pieces of legislation, such as in this bill. As such, I do hope that my noble lords will agree that it is reasonable that we should follow the rules set by the Act in order to ensure coherence, which will ultimately was debated and passed by this House. The EUWA gives flexibility for future legislation to provide for this level of parliamentary scrutiny, which is considered appropriate, and that is what we have done in this bill. I shall certainly, as noble Lord Hope has said, be considering all the issues that have been raised in this debate and taking them away. I hope, though, that the context which I has given of the strictly limited intended use of the Henry VIII powers and the reasoning that we have used for EU retained law has been helpful, and our commitment to engage with you further on this critical matters will mean that you are able to withdraw these amendments.
She's been very helpful and said that she'll consider the points raised. Am I raising my hopes too high by expecting that the government may come forward with some amendment for report stage?
I think that the noble lord is right to expect that I will take these questions away and consider them.
My Lords, may I say that I'm very grateful to the noble lady, the Minister, for the way in which she's assured us that she is listening to the criticisms, that the government has seen the point of them, and that she will consider them before report stage. In those circumstances, I will be inviting the House to accept my withdrawing the amendments. But I would say that what is very important is that it is not enough to give assurances as to how the government now intends to use the powers, for all the reasons we canvassed on Tuesday. What is important is that the government considers how far the powers need to go and how far they can be limited in order to achieve the object that she seeks to achieve, and only the object that she seeks to achieve. And if the bill comes back limited in that way, then it may well be that she'll get a much more favourable wind when she seeks to put such a power through at the report stage. I would also suggest that she asks the noble Lord Wilson of Dinton whether there is now a parliamentary barrister acting as parliamentary counsel who will take the same rather tough view on the extent of powers that are taken as that consulted by him when he was a junior official. Because it's that kind of rigour that is necessary, and that kind of rigour must be brought to bear upon the powers. May I just say a word or two about the point made by the noble Lord Lansley and the response by the noble and learned Lord Hope. It does seem to me that a greater use of appropriate conjunctions, making clear when and is meant and when or is meant, would help in Clause 5, it would help in Clause 1, and a little bit of English grammar might go a long way to improving this and other legislation. Leave to withdraw this amendment.
Is it your Lordship's pleasure that Amendment 26 be withdrawn? Amendment is by leave withdrawn. Amendment 27, Lord Lansley.
I'm grateful for the opportunity to move Amendment 27, which is linked with Amendment 41. Noble Lords will recall at second reading there was considerable, and indeed again on Tuesday, there was considerable debate about the issue of the distinction between those agreements which are effectively rolled over, their existing agreements, which the purpose of which is to replicate the EU reciprocal healthcare agreement presently in place, and other agreements made under this legislation. Now, in the previous group, we discussed the Henry VIII power and under what circumstances it should be applied. This is different. This group is about, from my point of view, is about the question of which agreements should be subject, when implementing legislation is required in relation to those agreements, which agreements should be subject to what procedure by way of parliamentary scrutiny. Now, thinking about it after our debate at second reading, it struck me that there was a clear distinction to be made between what I call continuity healthcare agreements, which, as one will see if one looks at Amendment 41, are defined as agreements, the purpose of which is to replicate the terms of agreements made presently under the EU social security regulations as they're specified. Now, those are continuity healthcare agreements. Those are those agreements that are being rolled over. We don't, they are not novel, they don't bring new issues to bear. The purpose, I think, is entirely agreed, that we want to make it swift and certain that existing rights under EU reciprocal healthcare are reproduced in future and implemented rapidly. So it seemed to me that it was perfectly reasonable for those agreements to be subject to the negative procedure. Therefore, if we could define continuity healthcare agreements in Amendment 41, it will enable those that are not continuity healthcare agreements to be subject to the affirmative procedure, and that's what Amendment 27 would do. It would require the additional time and scrutiny to be devoted where there is a new healthcare agreement, or, as it happens, a substantial amendment to an existing healthcare agreement. So to that extent, I do very much commend, again, obviously at this stage I'm not sure whether the drafting would necessarily meet with my noble friend's approval, but the purpose at this stage is in any case to try and establish the principle that there are two kinds of healthcare agreements that come forward. We spent a lot of time on Tuesday with members of this House arguing whether or not any extension of the powers beyond existing agreements was desirable or not. Frankly, I think I don't want to re-enter that debate this afternoon. We had that debate on Tuesday. The purpose, however, I think now is to say that if we do proceed down this path with this bill, substantially amending reciprocal healthcare agreements that presently exist, or adding new ones, we would want to make a distinction between those which are rollover agreements, i.e. continuity healthcare agreements, and those which have substantial changes in them. So I do commend it to my noble friend and beg to move Amendment 27.
Amendment proposed, page 3, line 37. At end, insert the words printed on the marshalled list. Amendment 27.
Can I first of all make a couple of apologies? One to my noble friend, Baroness Thornton. She's absolutely right about the House of Commons, our colleagues there, anticipating this problem and the wide nature of the powers of this bill and dealing with it. She's absolutely right, and I accept the correction. Indeed, it was my noble friend Baroness Thornton who alerted me to the powers of the bill and got me involved. Maybe she's regretting it now, but I am grateful to her. Can I also apologise to the Minister for not being able to get to the meeting that she'd arranged with the noble Lord, the Earl of Dundee, and noble Lord Marks, and I was invited along. But we had a very long Labour group meeting yesterday. I will not go into any of it in any detail whatsoever, because I'm bound to total secrecy in relation to that. So you can imagine what fun it was. But I want to deal with just the distinction between negative and affirmative instruments. In my previous speech, I said I'm concerned about the way in which statutory instruments are being used more and more and inappropriately. This deals with at least affirmative resolutions are better than negative instruments. As things stand, the Secretary of State has very extensive powers through this bill. As the Delegated Powers and Regulatory Reform Committee said, they're of breathtaking scope. And if all future legislation relating to this bill were to be laid through a negative procedure, then parliamentary accountability and scrutiny would be further undermined and substantially undermined. Introducing the maid affirmative as per the amendment would be in line with the majority of other legislation, and crucially the government could not legislate in the knowledge that they would not face parliamentary scrutiny. The government argues that this absence of scrutiny will mostly relate to administrative actions. However, given the breadth of the Secretary of State's powers, the negative procedure could easily be misused. My Lords, in her concluding remarks at second reading of this bill, the Minister Baroness Blackwood said she heard the noble Lord's preference for wider use of the maid affirmative procedure, and she said, I will reflect on it more as we head towards committee. Well, we're at committee now, and I wonder if she will tell us the result of that reflection, or whether we have to wait further to find out about it. The BMA echoed this stance, and they insisted, and I quote, that any new powers granted to the Secretary of State are proportionate, subject to thorough scrutiny, and that all regulations are subject to the affirmative procedure in Parliament. I hope that we will get that assurance. And if I can finally return to that wonderful speech of the noble Lord Judge that we had on Tuesday, and I've quoted from it twice or three times already, but if I can do it again. He went on to say, I will try not to bang on any longer. Well, I'll try not to bang on too long as well. If we had time and exit day was further away, I should propose that this bill should be sent packing back to the government to redraft it and produce a bill that is constitutionally acceptable. Hear, hear, I say to that. Hear, hear. However, the option is not open because the healthcare of our citizens in Europe and the EU citizens here must continue and survive. And that's what we're faced with. It's the gun pointed at our head. If you don't agree to this, then we're going to go out of the European Union with a bang, and our people will suffer. So that gun is being put at our head. It's a pity that it is. Otherwise, I would support the noble Lord Judge in getting rid of Clause 5 altogether. But meantime, all we can do is try to improve it a bit. And I hope the Minister will give us an assurance that the statutory instruments will be of the affirmative nature and not of the negative nature.
Lords, within this grouping, I will speak to proposed Amendment 34, reflecting concerns about the wide scope of regulations. This seeks for them to be subject to affirmative rather than negative procedures. That in turn would enable Parliament to be able to exercise more scrutiny. However, this aim should perhaps be viewed in three different contexts. Firstly, reciprocal healthcare arrangements between the United Kingdom and the European Union. Secondly, between the United Kingdom and countries outside the European Union. Thirdly, and apart from affirmative or negative procedures, other possible ways and means for addressing what so far may appear to be an imbalance of too many powers given to the Secretary of State and too little influence assigned to Parliament. On reciprocal healthcare plans between the United Kingdom and the European Union, my noble friend the Minister will be right to caution that we should retain negative procedures. For after a healthcare agreement is in place, those would be better able to avoid uncertainty and time delays in order to protect the interests of all direct participants within the new scheme. Yet, reciprocal healthcare arrangements between the United Kingdom and the European Union is a different matter. Does my noble friend the Minister concur that in their regard there is a strong case for replacing the use of parliamentary negative procedures with affirmative ones, and that to do so would provide a good balance between the influence of Parliament, which becomes greater, without at the same time putting people at risk within the new scheme? Then, apart from affirmative and negative procedures, other expedients which might serve to reduce a perceived anomaly or imbalance, that from the bill the Secretary of State has too many powers and Parliament too few. The noble Lord Foulkes of Cumnock has already referred to the noble and learned Lord Judge and others, and to all those who collectively have expressed concern about this. Therefore, might my noble friend the Minister be able to say in what way and to what extent she might be able to achieve some accommodation between now and third reading?
My Lords, in this group I will speak briefly. Amendments 35 and 36 are in my name. And what I say is entirely without prejudice to what I said in the last group, that changing the procedure does not make it acceptable for statutes to include fundamentally inappropriate delegations such as are included in this bill. Nevertheless, we are now considering the bill, given the breadth of the powers as they currently are drafted, particularly those in Clause 2. And in that context, I draw attention to the use of the ghastly phrase, for example, to which the noble and learned Lord Judge drew attention on Tuesday, to allow for the widest possible powers and then to introduce them in a clause that starts, regulations under subsection 1 may, for example, showing therefore that the powers are entirely unlimited, is completely unacceptable. But that's the background against which we're considering the question of the appropriate procedure. And against that background, I do not believe that any regulations should be made under this bill unless they are made by affirmative resolution. Should there come a stage that the government comes back with the bill at report in which the powers of the minister were appropriately circumscribed, then there may be a case for some regulations of a minor nature to be amenable to the negative resolution procedure. And in particular, I listened with care to what the noble Lord Lansley said when he drew a distinction between rolling over agreements that already exist and the regulations in relation to the EU-EEA Switzerland agreements and others that we already have, and making new agreements and regulations in relation to them. And that may be a point in relation to which a distinction can be drawn, and no doubt the noble lady and her colleagues will be considering that as a possible distinction. But generally speaking, regulations of this type ought to be by affirmative resolution. Lords, if we're looking at a very different bill later on, then I do ask the noble lady and her colleagues to consider the Delegated Powers Committee's advice to departments in considering how the procedures should be adopted and which procedures should be adopted and the criteria which should be applied in choosing them.
I just wish to speak briefly on my noble friend Lord Lansley's amendments number 27 and 41. Now, noble lords will know that because of my role as a minister up until the end of the year, I find some of the provisions in this bill rather more defensible than other noble lords, and I know that that is a minority opinion. But nevertheless, my noble friend has said that she will reflect on the House's strength of feeling, and of course she has much greater wisdom than me on these matters. Nevertheless, I was struck by some comments made by my noble and learned friend Lord Mackay of Clashfern in the last group, where he talked about the scope of the bill, and I think that is relevant to the context of the amendments laid by my noble friend Lord Lansley. And that is, in a sense, the point that I was trying to make on Tuesday, which is there is no reason a priori why this bill should not have a broader scope. And indeed, as my noble friend pointed out, in other contexts, the House is arguing that similar bills ought to. But it does follow from that, I think, that the functions that would be carried out as a consequence of the bill are of two distinct types. One is what my noble friend called rollover bills, to provide the continuity with the EEA in Switzerland, and the others would be new arrangements, not necessarily new in the sense of with new countries, but of a new and deeper kind. And clearly that will be taking on a kind of relationship that doesn't have precedent when it comes to dealing with individual countries, even if it might have precedent as being modelled on those available with the EEA and Switzerland. I therefore think his logic of thinking about how the regulation-making powers ought to reflect that distinction is a sound one. Because there does need to be clearly a sensitivity. And that is also, I think, reflected in the timeliness and the urgency of what we need to do for one set of circumstances and what we might want to do with a longer-term global role. So I'm sure my noble friend, the Minister, will have reflected and be reflecting very carefully on these amendments. And I do think that if the goal of the bill, as I still believe it ought to be, should be to give us the broad scope, not only to deal with the consequences of leaving the European Union, but to build a different, a broader, more global set of relationships, which I think is of the kind of network that the House supports, then the arguments made by my noble friend, whether the specifics are right, I don't know. Others will be in a position to judge. But I do think there is a compelling case for a differentiated approach, and I look forward to hearing my noble friend, the Minister's comments on those amendments.
I'm just reflecting, listening to the noble Lord O'Shaughnessy, that going back to our debates on Tuesday, I think he's making the argument for two bills again, but there we go. And certainly he's quite right about differentiation. I'd like to thank the noble Lord Lansley for introducing this group of amendments, all of which seek to curb the powers of the Secretary of State is seeking in Clause 5 of the bill. And I'm speaking to Amendment 33 in this group. This amendment would ensure regulations are made under the affirmative procedure, indeed. And what we've sought to do here is to use the affirmative procedure in the event of a no deal, which would enable the government to bring in replacement bilateral arrangements immediately. And that's because we're concerned that delays under the draft procedure would leave British citizens and EU citizens not covered by a health agreement with serious implications. So what we can see here, my lords, is a group of amendments which point in the same direction, and they come from every part of the House. They are in agreement broadly with both the Delegated Powers Committee reports and the Constitution Committee reports, and the Henry VIII powers in Clause 5.3 and Clause 5.4 provide regulations, as noble lords have said, amend, repeal and revoke retained EU law. And I very much welcome the fact that the noble lady, the Minister, in the previous debate has said that she intends to consider what has been said. So I will resist the temptation to quote the Constitution Committees and what he has had to say about this, because I know noble lords have read those at length and they are very influential. Well, my lords, these powers have been mentioned by noble lords all the way through this committee stage. Clause 2 and Clause 5 are particularly worrying, to put it mildly. What concerns me, my lords, is the government's reaction to the legitimate concerns expressed so clearly by both the highly regarded Lords committees, upon whose advice we depend in our scrutiny of legislation, and its overuse of the words flexibility and capability, and the argument that the bill has to be forward-looking and it needs to have these powers to provide that flexibility and capability. I was brought in mind of the last general election, where the government coined the phrase then strong and stable, and it didn't convince anybody. And I'm not sure that the flexibility and capability is convincing noble lords as a reason for having these powers. I mean, they're a good reason for what the government wants to achieve, but as a justification for the powers that are in this bill at the moment, they are not a compelling explanation for why those powers need to be there. And since the noble lady the Minister seems to now to have realised that from every part of the House, including her own benches, that we take these matters particularly seriously. And it's not because there's a desire to stop government from acting, indeed, absolutely not at the moment. It is because our system of checks and balances and accountability require that legislation is subject to proper scrutiny to safeguard citizens from the tendency of governments, and it's all governments, to charge on and ride roughshod to implement their wishes without let or hindrance. And I know that some officials see this as some kind of game or tussle to see what they can get away with, particularly at the moment. But as the noble Lord Wilson said in his wise remarks on Tuesday, you cannot put these powers in because they might just be useful. So although I will resist in joining the noble lord in repeating the words of Margaret Thatcher as he did, I do agree with his sentiment that the bill as drafted breaks all the rules of our constitutional understanding, and I now hope that the Minister is taking that seriously, because that's the challenge before the Minister and the House, is to amend this bill so that it fulfills its primary function, which is to provide healthcare cover for millions of UK citizens and ensure healthcare for UK citizens living and working in the European Union and European citizens living and working in the UK. In other words, it's about individuals' lives and their health. And we believe that with the right amendments, like the ones defined in this group, that they will refine the scope of the bill and give the Secretary of State the appropriate powers, and that is an achievable task.
My Lords, I would like to offer my thanks to my noble friend, the Lord Lansley, for his amendments 27 and 41, the noble Baroness Lady Thornton for her amendment 33, my noble friend, the Earl of Dundee, and the noble Lord Foulkes for amendment 34, and the noble Lord Marks for amendments 35, 36 and 38. Each of these amendments speaks to concerns that we've heard during the passage of this bill to date about the breadth of the regulation-making powers and the scrutiny afforded to them. And I wish to open by saying that I am listening very carefully to these concerns and to assure the noble Baroness Lady Thornton that I see this process neither as a game nor a tussle. The suite of measures that we are introducing around reciprocal healthcare is intended entirely to reassure UK citizens living in Europe and elsewhere, and EU citizens living in the UK, that we will be working hard to ensure continuity of care for them in what is an uncertain time, but also that we are thinking forward-looking, that we may be able to provide care in other places, and that is something that a government should be doing. So, to assist with our consideration of these issues, I thought it might be helpful if I were to set out the intention of some of the delegated powers as drafted, as we haven't yet had a chance to do that in much detail. So, as I previously indicated, Clause 21A is intended to be used to set out the detail of complex payment arrangements under reciprocal healthcare deals. And this is because payments can get done in a variety of ways. So, for example, the UK pays France the actual cost of treatment provided. That means means it pays a claim for the cost of each person's individual treatment, whereas in Spain we pay an average cost per person of treatment provided. With Portugal, on the other hand, we offset payments. That's why that power has been drafted as it has. Clause 2.1b provides for regulations to be made in connection with the provision of healthcare abroad outside of a reciprocal arrangements, which allows us to put in place complex arrangements outside of a bilateral agreement in an urgent situation. That is designed specifically for an EU exit situation, which may be an emergency. Clause 2.1c is needed to give effect to comprehensive healthcare agreements entered into with another country or international organisation such as the EU, and this provides the power to implement agreements into domestic legislation, and we believe it would be unworkable to produce new primary legislation to implement each and every agreement on an individual basis. I'm sure the House would agree with that. Clause 2.2 sets out the examples of the type of provision that might be included in regulations under 2.1. We have said before it's an illustrative list of the kind of provision that would be already included, and I have taken note of the concern about conjunctives under this clause. Clause 2.2a highlights that complex healthcare agreements may include a mechanism for calculating payments and regulations, but would need to specify how the cost of healthcare would be calculated between different countries. Clause 2.2b indicates that regulations may establish eligibility criteria that specifies which people could access healthcare outside the UK, and establishing robust eligibility criteria is key to prevent misuse and abuse of healthcare, as my noble friend Lord Lansley has already referred to in previous debates. Clause 2.2c indicates that regulations under this bill may also be used to specify the types of healthcare covered in relation to healthcare arrangements abroad. For example, under the current EU reciprocal healthcare scheme, the EHIC scheme provides access to needs arising, whereas S2 route provides access to pre-planned treatment. That would be how we would enter that into domestic legislation, as noble Lord Foulkes would be concerned about. Clause 2.2d indicates that the regulations may provide for set-off arrangements. This is when the amounts that both countries charge for reciprocal healthcare are offset, with only the difference being paid by the country owing the most money. This is the kind of arrangement that we have at the moment with Portugal. Clause 2.2e indicates that regulations may provide for determining reimbursement levels, including caps. For example, the government may negotiate future agreements that will bear the cost of certain treatments abroad, but only up to the cost of the treatment on the NHS, which is the arrangement that we have with some of our reciprocal healthcare at the moment. Now, noble lords have rightly drawn attention separately to issues of dispute resolution and rights of appeal, as we debated in a previous group. Clause 2.2g indicates that this is something the government recognises as important, and regulations made under Clause 2.1 can be used to make domestic provision about appeals and dispute resolution processes pertinent to an agreement. Clause 2.2h indicates that regulations may be used to confer functions on the Secretary of State or any other person, as we already discussed in Group 1. And finally, Clause 2.2.1 indicates that regulations may be used for delegating functions. Reciprocal healthcare agreements are implemented, as we said, in partnership with a number of NHS bodies and organisations, but also with non-NHS organisations such as DWP, who obviously cover pensions and social security. So they do need to be identified, and they do need to be given a clear legal responsibility and operating mandate to do so. Now, the Department does... Please, yes.
All of these powers exist at the moment. All of these arrangements exist. They exist at the moment, and they haven't needed the powers that you're asking for in this bill to do it. So a point that was made on Tuesday was that why are we looking to have such huge powers when actually we've managed without such huge powers in the past?
For the implementation of international healthcare arrangements, these powers exist within EU legislation. We do not have these powers for implementing international healthcare arrangements within domestic legislation at the moment. That is why these are being introduced. The Department believes that the negative procedure is appropriate for implementing those powers, for the use of the delegated powers in order to arrange those specific implementation purposes, which I have just laid out, and balances the appropriate level of scrutiny with parliamentary time. However, I have heard the debate. I've been listening very closely to the discussions which have come forward. I take very seriously the concerns which have been raised by your lordships, by the DPRRC, by the Constitutional Committee, and I hope, though, that you will also understand that we do need to ensure that the government does have the legislative tools to implement the agreements that we reach, especially the ones with reciprocal healthcare at EU exit. I would like to work constructively with the House to further consider these issues in detail as we progress the bill to report stage, and I hope that, and I will be making myself and officials free to discuss the breadth of the regulation-making powers further at an open session next week. So I hope that with these reassurances and this explanation, your lordships will feel free to withdraw your amendments at this stage.
I'm very grateful to my noble friend and indeed to all of those noble lords who took part in this short debate. I thought it was very constructive, and I'm especially grateful to my noble friend Lord O'Shaughnessy for his support for my two amendments. I thank the Minister for her willingness now to think about these issues positively and constructively, and we will return to it at report, and I look forward to that. But on the basis of that helpful assurance, I beg leave to withdraw my amendment.
Is it your Lordship's pleasure that Amendment 27 be withdrawn? Amendment is by leave withdrawn. Amendment 28, Lord Patel, not moved. Amendments 29 and 30, Lord Marquess of Henley-on-Thames, not moved. Amendment 30A, Baroness Humphreys.
My Lords, first of all, can I apologise for not having been able to take part in the second reading debate on this bill. My Lords, this group contains two amendments in my name and that of my noble friend Baroness Jolly, and a further amendment in the names of the noble lady Baroness Thornton and my noble friend Lord Wallace of Tankerness, which I also support. My first amendment, 30A, ensures that the government may not, by regulation, repeal or revoke primary legislation made by the devolved legislatures without their consent. And my second amendment, 30B, ensures that the acts passed in this Parliament giving powers to the devolved legislatures may not be modified without their consent. It could be argued, my Lords, that this is what this bill tries to do. I'm grateful to the noble lady, the Minister, for a response to a question posed by the noble lady Baroness Finlay during the debate at the first day at committee, but would like to use my two amendments to open further discussion around the issue of legislative consent by the devolved administrations and how this is impacted by the bill. In the light of the noble lady's response on Tuesday, which was made after my amendments were laid, I'll keep my contribution relatively short at this committee stage. Many of your lordships have already spoken on this bill and pointed to what the wide-ranging powers conferred by on the Secretary of State by Clause 2.1 of this bill. Powers which the Delegated Powers Report has described as inappropriately wide and as having breathtaking scope. As that committee points out in their report of the 14th of February, their conclusions were supported by the Constitutional and Legislative Affairs Committee of the National Assembly of Wales on the Welsh Government's Legislative Consent Memorandum on this bill, where these inappropriately wide powers can be seen to have an impact on the devolved legislatures. This House's Constitution Committee records the decision of the Scottish Parliament to agree to an LCM in these exceptional circumstances, but it also records that the Welsh Government has so far declined to give its legislative consent. They described the Welsh Minister for Health and Social Services, Vaughan Gething AM, as expressing particular concern about Clause 2 because, and I quote, it doesn't require consultation or consent from ministers in devolved administrations. My Lords, the Welsh Government would expect to be consulted and their consent sought on this issue because powers over the health service have been devolved to Wales by this Parliament. But Clause 2 is silent on this, and as such, it's an important omission from this bill. The Welsh Government acknowledge, of course, that an LCM will be required by the UK Government because provisions in the bill modify or fall within the Assembly's legislative competence. But they also note that, and again I quote, any healthcare agreement entered into on behalf of the UK will affect the NHS in Wales, and this legislation will therefore have a significant impact on a devolved policy area. And one might add, potentially a significant impact on their finances too, if they're expected to implement a UK policy that they have not budgeted for. Rightly, the Welsh Government is seeking assurances from the UK Government to ensure that the Welsh Government is involved in matters that affect devolved areas in Wales, and that this is recognised in the bill. My Lords, the noble lady, the Minister, said on the first day at committee that she is in advanced discussions with the Welsh Government, and she hoped to be able to report back on this in more detail at report. So I'll not detain the House any further today on this issue. I merely wish to outline my concerns and draw your Lordship's attention to them at this stage, and look forward to that further debate the noble lady has promised. I wish to move.
Page 3, line 42. At end, insert the words printed at the foot of page 1 of the Marshal's list and at the top of page 2. Amendment 30A.
Lords, again, I apologise that I wasn't able to speak on second reading, but I would wish to speak in support of amendment number 42, which is in the name of the noble lady Baroness Thornton, and which I have added my name, and it is about a duty to consult devolved administrations before making regulations under this Act. My Lords, my noble friend Baroness Humphreys has already given a flavour of the important constitutional and devolution issues which arise as a result of these particular provisions. As she indicated, unlike the Welsh Assembly, the Scottish Parliament actually has passed a legislative consent motion in respect of this bill, quite exceptionally, because the position of the Scottish Government is to withhold consent generally with regard to legislation in respect of the EU withdrawal, but it took the view that it would do so. It would seek consent if there were exceptional circumstances, and the Scottish Government believes that in this case there are exceptional circumstances, and that view was supported in turn by the relevant Parliamentary Committee in the Scottish Parliament, and indeed last month by the Scottish Parliament as a whole. As I said, my Lords, it's a relatively modest amendment that's requiring consultation. The explanatory memorandum that accompanies this bill makes it clear in Appendix A, or Annex A, that there are areas, I think it's specifically clauses 1, 2 and 4, where a legislative consent motion is required. And I think it's very obvious, because here we have a situation where international agreements are made by a member state, in this case the United Kingdom. We're making them with other countries, but it's in respect of a subject matter which is devolved. And perhaps that is made very clear, because I'm sure the noble lady, the Minister, will be very familiar indeed with the National Health Service Scotland Act 1978, Section 2CB, which refers to the functions of health boards outside Scotland. It says that where it is the function of a health board to provide or to secure the provisions of a service, the health board may secure the provision of that service outside Scotland. And for the purposes of securing the provision of any service referred to in subsection 1, a health board may make such arrangements for the provision of the services they think fit, and in particular may make contractual arrangements with any person and anything done by a health board in pursuance of subsection 1 or 2 is to be regarded as done in the exercise of functions of the Scottish ministers conferred on the health board by an order under section 2(1)(a). And if one looks at the annotations in the very helpful legislative website, indicates that these sections do have their origin in EEA treatment costs or regulations dealing with that. So clearly there is a responsibility, or this impinges on devolved responsibilities to Scottish ministers. The legislative consent motion was passed by the Scottish Parliament, but I think it's also important to note, and my noble friend Baroness Humphreys mentioned the Constitution Committee, and in its report on this bill at paragraph 13, it recommends that the Government sets out how it intends to manage overlapping competences in relation to this bill and other policy areas. I think it would be very useful when the Minister comes to reply if she could give us some indication how the UK Government intend to do this. Because obviously there are areas, for example, a regulation specifying or describing evidential administrative requirements or processes actually could have an impact on administrative processes within the responsibility of the Scottish Government, or indeed of health boards within Scotland. And I think it is instructive, my Lords, that when the Health and Sports Committee of the Scottish Parliament took evidence in relation to the legislative consent motion from Mr Paul Gray, who, up until he stood down this month, was the Director-General for Health and Social Care and Chief Executive of the NHS in Scotland, in his evidence to that Parliamentary Committee, Mr Gray said, and I quote, "The Scottish Ministers and the UK Government agree that the bill impacts on the devolved function of health. As a result, it requires the consent of the Scottish Parliament. UK Government officials have indicated that the bill will be amended to recognise the responsibility of the devolved administrations. The proposal is to introduce a requirement to consult the devolved administrations and to agree a memorandum of understanding with them before regulations can be introduced that impact on devolved matters." And subsequently, in answer to questions, Mr Gray went on to say, "As I said in my opening statement, UK Government officials have indicated that the bill will be amended to recognise the responsibility of the devolved administrations. The particular point to which I would draw the Committee's attention is the requirement to consult devolved administrations and agree a memorandum of understanding before regulations can be introduced that impact on devolved matters. The distance that I can go based on what we have, and bearing in mind that these are proposals, is to say that the current proposal is that there is a requirement to consult the devolved administrations before regulations can be introduced." My Lords, that was evidence given by the then Chief Executive of the Health Service in Scotland to a Scottish Parliament Committee, undoubtedly based in good faith on discussions he'd had with officials at UK Government level. This amendment, I think, seeks to give some substance to what would appear to have been agreed at official level, and I hope that the Minister feels able to accept it.
In following the noble Lord Wallace, can I strongly support Amendment 42 and also the amendments moved by noble Baroness Humphreys? And she made the very important point that the Welsh Government has not given its legislative consent. And I know that there's considerable concern in the Welsh Government, and I say that as a former Secretary of State for Wales. By the way, I do welcome the Minister to her place as a refugee from the House of Commons, like me, except I wasn't defeated. But she's very welcome, and I wish her all the best. I resigned. But what worries me about this, and I hope that she can give us concrete assurances when she speaks, that it seems to be part of the DNA of Whitehall on the BrExit agenda that they don't have regard for the devolved governments. And there's the only references that I can find in this bill to the Welsh Government's, the Scottish or Northern Ireland devolved legislative bodies, is that right at the end, when it says it applies to them. Now, it is absolutely essential that there is at least a requirement written into this bill to seek legislative consent and to consult, because, of course, health policy is devolved to Scotland, to Wales and to Northern Ireland. And the government's got form on this issue in the way that it approached the whole Brexit legislation earlier on in the process and had to... there was a crisis, as your Lordship's House will recall, where there was a real confrontation with the Scottish Parliament and the Welsh Government, and may well have been with the Northern Ireland Assembly if it had been up and running. It seems that it must be in the DNA of Whitehall that they simply do it again. And that really worries me, and I hope that she can give the kind of reassurances which will mean that we don't have to vote on something very similar to these amendments at report, because I think we will need to, and seek to defeat the government if there isn't a major concession made. So can I ask her to, in endorsing what the noble Lord Wallace and Baroness Humphreys said, ask her to give very specific assurances, and that she can spell out that she will only, if she does amend this bill, as I hope that she will give us assurances that she's going to, that she will only do so having agreed the terms of those amendments in precise terms with certainly the Welsh Government and the other devolved and the Scottish Parliament, and certainly consulting officials in the Northern Ireland departments.
It might be useful if I just reassure the House in response to the comments made by the noble Lord Hain that there was extensive engagement with the devolved administrations in advance of the bill, not just by officials, but myself as Minister spoke to my counterparts in Scotland, Wales, and of course it wasn't appropriate to do it in quite that way in Northern Ireland for obvious reasons, there not being an executive. That happened before the publication of the bill and subsequent to the publication of the bill. And so this has been going on for several months. It was one of the reasons that we were very pleased to get the legislative consent motion in advance from the Scottish Government, because clearly everyone recognised the benefits that flow to this for inhabitants of all parts of the United Kingdom. But I think it is useful for the House to know that this isn't an activity that has simply been undertaken as a bolt-on in response to concerns raised during the passage of the bill, but it was absolutely baked in from the beginning, and it has been our intention to move in the appropriate way with no, if I may just finish, with no procedural or constitutional novelty of the kind that the noble Lord fears.
That he's given way. Why then does the Welsh Health Minister and the Welsh Government, why are they still so concerned about this bill? And I'm encouraged that there were these consultations, but why is there the concern that there evidently is?
Well, I think there are the different governments have clearly taken different approaches, and the noble Lord will know that it doesn't automatically follow that you can agree, even if you want to know where you all want to get to, that you can agree it overnight. But I'm sure my noble friend the Minister will be able to update us.
To endorse everything that my noble friend Lord Wallace of Tankerness has said. He has the great distinction of having been for some time Deputy First Minister of Scotland and for a short time Acting First Minister of Scotland. So there are very few people who can claim that distinction. And I agree with, as I say, with every word he said, and I describe him as my noble friend in every sense of the word, by the way. I hope that's not misunderstood. Can I also say that Baroness Humphreys, I agree with everything that she said. What I find difficult, however, to understand is why this has received the legislative consent of the Scottish Parliament, which is usually more reluctant to give legislative consent, and not of the Welsh Parliament. And I can only assume that it's because Lord O'Shaughnessy kissed the Blarney Stone before he went to Edinburgh again, and was able to persuade them. But I'd be interested to know why, and maybe I'll try and find out before we get to the report stage with my contacts in Scotland. I suspect that a lot of the points that have been raised, the omissions in this bill, are because this legislation, like much of the legislation we're considering at present, is being rushed because of Brexit, and not proper consideration is being given. And I don't blame the officials. They've got so much work to do, and they are. I went to a briefing that they held right at the start, and I know they're very hard-working officials. And I would rather see them doing more constructive work than the work they're some of the work they're being required to do in relation to BrExit. But there is a tendency, and I agree with the noble Lord Hain, and I find this not just in health but in a whole lot of other areas, that there are some officials, particularly at the higher level in Whitehall, who still haven't come to terms with devolution. They still don't quite understand what devolution means, and that the health service in Scotland is run completely by the Scottish Parliament. And it is, I know it's difficult for some of them, the ones who've been involved since before devolution, to fully understand that. And I hope we'll do more to get that over as we move forward. And I hope that the next government, whatever shade it is, non-conservative government, let's put it that way, takes more care of the devolved settlements. But specifically, can I ask the Minister, Lord O'Shaughnessy said he has had discussions. Can I ask the Minister if she could give us an assurance that she will, since she's just taken over very recently, and I don't think she'll have had time, she'll have an opportunity to meet with Jean Freeman, the Minister for Health in Scotland, Secretary of State, or Health Secretary in Scotland, to discuss this, but between now and report stage, if possible, and report back to us on the more detailed attitude of the Scottish Parliament in relation to this, and that they are satisfied with some of the points that have been raised by the noble Baroness Humphreys and the noble Lord Wallace of Tankerness.
My Lords, I'm moving Amendment 42 in the name of my noble friend Lady Thornton and the noble Lord Wallace. He's already spoken to the amendment and covered many of the points we need to raise. It focuses on ensuring that the commitment to involve, consult and have regard to the views of the devolved administrations before regulations on new health agreements are drawn up is on the face of the bill and is set out as a clear duty on the Secretary of State. The amendment would ensure that before making any regulations under this Act, the Secretary of State must consult the Scottish Government, the Welsh Government, and if there's no executive on the day in which the Act is passed, the relevant Northern Ireland Department. The noble lady, the Minister, did tell the House at second reading that the Government had been working with the devolved administrations and fully understood the need for a legislation on reciprocal healthcare agreements to fully respect the devolution settlements. This amendment will reassure the House on this matter, and I think the reassurance does have to be given, as the speakers have illustrated up to date. We also support the principle of the safeguards set out in the new amendments 30 and 30B, 30A, moved by the noble lady Baroness Humphreys. As we've heard, given the significant impact on devolved authorities, it's crucial that their interests are appropriately considered in the development of reciprocal health arrangements, and that mechanisms are in place to ensure that each administration contributes to the making of decisions that affect Scotland, Wales and Northern Ireland. I'm looking forward to the noble lady's update in respect of the Scottish Government. The noble Lord Wallace provided us with some of the detail of the ongoing discussions, despite them having carried the legislative consent memorandum. So I'm looking forward to her update on the response to the issues that he's raised. As we've heard from the noble lady Humphreys and my noble friend Lord Hain, the Welsh Government so far declined to recommend the Welsh Assembly give its legislative consent to the bill. The Welsh Minister for Health and Social Services expressed particular concern about Clause 2 because it doesn't require consultation or consent from ministers in devolved administrations. The Minister of State's offer, however, to amend the bill to place a statutory duty on the UK Government to consult the devolved administrations where regulations under Clause 2 of the bill would be in their legislative competence is welcome. This would be underpinned by an accompanying memorandum of understanding stating that all parties will seek to proceed on the basis of consensus. Draft agreements would be discussed with the devolved administration before they're shared with third countries, and ministers would be consulted on the content and drafting of regulations made under Clause 2 of the bill, where they relate to devolved matters. Can the Minister confirm this in this House? This would be a welcome step that would help to create a positive framework where the future of reciprocal healthcare arrangements can be discussed on a collaborative and constructive basis. Consulting before making regulations will also smooth the process for making regulations, given that any statutory instrument which amends Welsh, Scottish or Northern Ireland primary legislation would of course be subject to statutory instrument consent memorandum in each legislature, which will decide whether to recommend that consent is given in the circumstances. As noble lords have underlined, the importance of reciprocal health agreements to the people of Northern Ireland and Ireland have been raised by noble lords both at second reading and in our separate amendment dealt with earlier. A statutory commitment to consulting with seeking the views of either the Northern Ireland Executive or the relevant NI Department on regulations enacting new healthcare agreements would provide reassurances about the continued funding arrangements. Finally, I hope the Minister will be able to set out and respond to the recommendation from the Constitution Committee report, which underlined the need for the Government to set out how it intends to manage those overlapping competencies in relation to this bill. As the committee points out, that while the making of international agreements is a reserved matter for UK government, healthcare is a devolved matter, and as all powers are repatriated from the EU, the potential for overlapping competencies increases, as does the scope for disagreement about such issues, and this will need to be managed. My Lords, our amendment places the Minister's commitments to consultation, involvement and the devolved administrations on the face of the bill. No more, no less. I beg to move.
My Lords, I am grateful to the noble Baronesses Lady Jolly and Lady Humphreys for amendments 30A and 30B, and to the noble Baroness Lady Wheeler for moving amendment 42 on behalf of noble Baroness Lady Thornton, for the opportunity to address this important issue of engaging and working with devolved administrations. As we take this bill forward at pace, we do endeavour to do so in a way that is collaborative and respects the devolution settlement and the conventions for working together. And to that effect, I do have to say that the noble Lord Hain's contribution was rather disappointing in implying that the government has anything but the highest regard for the role of the devolved administrations in this matter. Indeed, as the noble Lord Wallace describes, the Department has had and continues to hold constructive discussions both at ministerial and official levels with all the devolved administrations on this bill and on the underlying policy. And as your Lordships have already noted, the regulation-making powers in this bill do provide us with a legal mechanism to implement international agreements into domestic law for the benefit of UK nationals. This is a UK competency, but we do recognise that some parts of the bill, powers may be used in ways which relate to devolved matters, and by that we mean the domestic healthcare elements. And so with that in mind, as my noble friend Lord O'Shaughnessy has said, we are delighted that the Scottish Parliament has granted the legislative consent motion to the bill. We have had positive and constructive engagement with colleagues in the Northern Ireland Department of Health and in the Northern Ireland Office, and we're grateful for their support and their agreement to ensure that the bill applies and extends to Northern Ireland. And we are working very closely with colleagues in the Welsh Government to secure their support for a legislative consent motion. And to that end, as the noble Lord Wallace will, I hope, be pleased to hear, we will be introducing a government amendment at report stage which places a statutory duty to consult with the devolved administrations where regulations under Clause 2 would make provision that would be within the legislative competence of the devolved administrations. And furthermore, I can confirm that we have now agreed a memorandum of understanding with the Welsh Government to accompany the amendment. This MOU sets out how we intend to work with each other and indeed how the UK Government intends to work with all of the devolved administrations in respect of this policy area moving forward. In response, we expect the Welsh Government to lodge and support a consent motion in the Welsh Assembly very shortly. We've also been working to secure the support of colleagues in both Northern Ireland and Scotland to the terms of that Memorandum of Understanding. We hope that colleagues in both of those administrations will agree to the measures provided for the MOU following some very recent final discussions and changes with the Welsh Government. The MOU sets out a pragmatic and mutually beneficial working relationship to ensure that the devolved administrations will continue to have a vital role to play in delivering reciprocal healthcare for the benefit of all UK citizens. And in addition to that, it will enable devolved ministers to set out their views at an early stage of reciprocal healthcare policy formation, and where they relate to devolved matters, we will share the draft regulations we intend to make under Clause 2 with the devolved administrations before they are laid. We believe that this agreement is both pragmatic and practical, and it allows us to move forward in a collaborative way. I would like to put on record my thanks to my colleague, the Minister of State, Stephen Hammond, who is taking the lead on this engagement, and to acknowledge the positive relationships that he has sought to build with his counterparts in the devolved administrations. He has been speaking with them this very week. We consider that amendments to the Scotland Act 1998, the Government of Wales Act 2006 and the Northern Ireland Act 1998 would be outside the scope of regulations made under this bill, and it would be therefore unnecessary to place consent requirement on the face of the bill in this regard. But the UK Government is committed to working closely with the devolved administrations, now and in the future, to deliver an approach that works for the whole of the United Kingdom. My Lords, I hope that in reporting these positive developments I've been able to share with you today, you will be moved to withdraw your amendments
to the Minister. I'm very reassured by what she said, and perhaps I'll withdraw some of the tone of my remarks earlier without knowing what she was going to say. Could I ask her, though, to bear in mind, in terms of advice to Whitehall officials working on Brexit legislation of this kind, that it isn't an accident that these extra consultative arrangements which she's now describing were not in the original bill. And it's been true all the way through the Brexit process. And I'm afraid when I said it seems to be in the DNA of Whitehall, it's as if, this is the default position, that they don't put these consultative rights actually on the statute book. And I would ask her to use what influence she can and amongst the rest of her ministerial team in government to say that this mustn't happen again in any other legislation.
Part of the reason that this amendment has come at this stage is because it has been part of a negotiation, and we wanted to have agreement with the devolved administrations to ensure that it was in a manner which suited them. And so that is why it has been part of a process, because it was in agreement and in consultation, and rather than us putting it in at the beginning and then consulting afterwards. And I hope that as a result of that discussion and agreement, I will have reassured... please.
To acknowledge what she said, that an amendment will be brought forward. I think that's very welcome. We'd also just ask, is there anything technically defective with Amendment 42 that you're just going to accept it?
I think that we need to we're bringing forward the clause which we have agreed with the devolved administrations, and I think that it is appropriate to do that. But I do thank the noble Lord for his intervention, and on that basis I hope that your Lordships will feel free to withdraw your amendments.
Can I thank the Minister for her clarification and the excellent news that the Memorandum of Understanding has been signed. But can I just seek assurance from her that this matter will be reported on, or an amendment put forward at report stage, so that we can hear exactly whether the Welsh Government has completed the LCM process? Thank you very much. I beg to withdraw. Thank you.
Is it your Lordship's pleasure this amendment be withdrawn? Amendment 30A is by leave withdrawn. Amendment 30B, Baroness Humphreys, not moved. Amendment 31, Lord Marks, not moved. Amendment 32, Lord Marks.
For years, many of us have believed that the procedures for considering statutory instruments have been unsatisfactory. Whether any statutory instrument is to be passed by the affirmative resolution procedure or the negative resolution procedure, a question we've been discussing this morning, is not the fundamental point. The distinction merely determines the way in which the instrument comes before Parliament to be debated, if it does so. The more fundamental problem, which we all recognise, is that SIs are unamendable. Take it or leave it, every paragraph or none. We were reminded on Tuesday by the noble and learned Lord Judge that it's exactly 40 years since the House of Commons rejected a statutory instrument. In this House, we too have the power to reject statutory instruments by fatal motions. Last time we did it, or at least it was said by some that we did it, was over tax credits in 2015. Indeed, it was on the noble lady Baroness Mansour's motion when she was on this side of the House. On that occasion, the right-wing press railed against us for exceeding what it thought our powers ought to be and advocated our abolition. Anyway, the government set the noble Lord Strathclyde on us, after which the fuss rather died down. However that may be, fatal motions are very rarely passed by this House. Partly, I think, that's because they're seen as disrespectful of the primacy of the House of Commons, and partly, perhaps, as the noble Lord Foulkes pointed out, because the whips discourage fatal motions, sometimes in case they too face such motions when it comes to their party's turn in government. But I suggest that the power to reject delegated legislation is an important power and ought to continue, but it's a residual power to be used very sparingly and when the objection to an SI is very substantial indeed. The noble Lord Butler of Brockwell said in debate on the first group that we should use the power to reject SIs more often, to achieve amendment by sending them back for review and reintroduction. Well, that is a way of doing it, but it runs the difficulty that it may be too cumbersome, and for the reasons I have mentioned, I doubt that it would be a politically workable approach. Regret motions, which we often use, are useful, but they come too late in the process and the government doesn't have to take any notice of them. However, under my amendment, which the government would have to publish the draft 28 days before laying the regulations and give both houses a chance to debate the draft and to do so before it's actually laid. That would give us an opportunity in a relatively informal way to identify defects in instruments or particular provisions that ought to be removed. The amendment would avoid the need to go through the super-affirmative procedure, which many would advocate for some of the provisions in this bill, but would improve scrutiny. My Lords, under our existing arrangements, the power of scrutiny of secondary legislation is weakened by the lack of any provision for Parliament to point to particular provisions in an SI and ask the government to think again. Mine is, of course, a probing amendment. I suggest it's relevant particularly to the provisions of this bill, because the regulation power, as we've all considered, and many have made the point, is so general, so unrestricted, and so unpredictable in its likely or possible exercise. But this amendment may, and I don't suggest otherwise, be of more general relevance. It is intended to offer a way for Parliament to have an early opportunity of considering proposed delegated legislation in a draft before it is laid, to give MPs and peers an opportunity to consider and express concerns about a proposed statutory instrument or particular provisions within it, and to give government an opportunity to respond to issues raised in such exploratory debates. The amendment is expressed in the terms of a requirement on government to make those debates possible, because it's intended to emphasise that statutory instruments, though made by ministers, are made under powers vested in ministers by Parliament and are subject to parliamentary scrutiny. I don't suggest this amendment ought to apply to, or this type of procedure ought to apply to every piece of delegated legislation, but I do suggest it's worth considering. Because many of us believe that scrutiny has become too weak and the power of ministers too strong. This amendment is intended to explore a way of tilting the balance back in favour of parliamentary scrutiny, and would, I suggest, offer us one path to better and more carefully considered secondary legislation. I beg to move.
Amendment proposed, page 3, line 43, at end insert the words as printed on the Marshall list.
My Lords, just briefly, I listened carefully to the strong arguments put forward by the Noble Lord Marks on this issue, and I also await the Noble Lady's response. While we do have every sympathy with the intention behind the amendment and the Noble Lord's frustration that the House can either accept or reject a statutory instrument but can't amend it, while parliamentarians can and often do take note or reject motions, Parliament is ultimately at the mercy of the government to withdraw regulations and bring forward a revised draft which may or may not adequately address the concerns that have been expressed. Fatal motions are quite rightly used, rarely in exceptional circumstances. However, I do fear this amendment, and he's saying it is, the Noble Lord is saying it's a probing amendment, would be in this circumstance counterintuitive to the bill's primary objective of implementing reciprocal health agreements after Brexit. As my noble friend Lady Thornton said in respect of Amendment 33 in the earlier group, time's not on our side, and I fear that the approach contained in this amendment would lead to delays in implementing reciprocal health agreements. In the event of no deal, where millions of British citizens will lose their current access to healthcare treatment overnight, any delay on Parliament while Parliament debates and considers draft regulations would be catastrophic. Obviously, the delay that that would occur, such delay that the Noble Lord Marks' proposals would suggest, would of course have to be taken into consideration in any such future changes, and they certainly need to be discussed. Thank you.
My Lords, I would like to thank the Noble Lord Marks for suggesting an approach to the important issue of the appropriate levels of parliamentary scrutiny in Amendment 32 and for clarifying that this is a probing amendment. The Government clearly recognises the importance of appropriate levels of scrutiny in this bill and the secondary legislation made under it. Obviously, the hallmark of effective and responsible parliamentary system are the processes by which we draft, consider and test legislation. And I have been listening very carefully during this debate to your Lordships and your views on affirmative resolution procedure, and this is an interesting proposal by which we could consider draft legislation. But while the Government does support the spirit of the amendment and agrees that appropriate scrutiny is important, we do have questions about this particular approach. It is vital that we can make regulations that allow us to respond appropriately to a variety of possible scenarios arising not just from the UK's exit from the EU, but to any situation where we would need to implement regulations where this bill might be needed quickly and where it's required for a comprehensive international agreement. Such an approach for scrutiny would, we believe, increase the time taken to develop and lay regulations, and this may have quite a significant negative impact on our ability to bring forth timely regulations to provide healthcare to support hundreds of thousands of individuals who rely on this provisions, perhaps in a case which may be considered an emergency. We are conscious of the Constitution Committee's report on delegated powers, which indicated also that the use of different scrutiny procedures for statutory instruments can add to unnecessary complexity, and where possible the Government has agreed to use the existing model of enhanced affirmative procedure rather than creating a new variation. However, I do recognise the experience and the intention of the Noble Lord and the concern of the House, and so I would like to make an offer to discuss the issue of scrutiny of the regulation-making powers in this bill in advance of report stage on a general point, but not relating to this particular amendment. I would like to thank the Noble Lord Marks for raising this vital issue, but I do hope that after reflection he feels like he is able to withdraw it.
My Lords, I don't need to reflect very hard to withdraw what was plainly a probing amendment. I raised an idea. I accept the point that in the context of a lot of the regulations, particularly to replicate the European agreements that we've got, my amendment might not be appropriate. In the context of the wider issue of any other new healthcare agreements, if they are persisted with, it may be appropriate, and it's something that we would consider. I would like to say how grateful I am for the offer from the Noble Lady to consider the question of scrutiny. I'd like to accept that offer now, and so saying, I beg leave to withdraw this amendment.
Is it your Lordship's pleasure this amendment be withdrawn? Amendment 32 is by leave withdrawn. Amendment 33, Baroness Thornton, not moved. Amendment 34, the Earl of Dundee, not moved. Amendment 35, Lord Marks, not moved. And 36, not moved. Amendment 37, Lord Lansley, not moved. Amendment 38, Lord Marks, not moved. Amendment 39, Lord Lansley, not moved. Amendment 40, already debated, Baroness Jolly, not moved. Amendment 41, Lord Lansley, not moved. The question is that Clause 5 stand part of the bill. As many as are of that opinion will say content. Content. The contrary not content. The contents have it. After Clause 5, Amendment 42, Baroness Thornton, not moved. In Clause 6, Amendment 43, not moved. Amendments 44, already debated, Lord Judge, not moved. Amendment 45, Baroness Thornton, not moved. The question is that Clause 6 stand part of the bill. As many as are of that opinion will say content. Content. The contrary not content. The contents have it. In the title, Amendments 46 and 47, Baroness Jolly, not moved. The question is that this be the title of the bill. As many as are of that opinion will say content. Content. The contrary not content. The contents have it. That concludes the committee's proceedings on the bill. The House will now resume. My Lords, the Committee of the Whole House, to which the Healthcare International Arrangements Bill was committed, has gone through the same and has directed me to report it to your Lordships without amendment.
My Lords, I beg to move the House to now adjourn.
That the House do now adjourn.